never reported back.
Yes.
Did you have any dealings with General Sibia after that engagement regarding Mr. Bushoka's kidnapping? If so, can you just quickly articulate the nature of the dealings?
Dealings meaning?
Any engagements with him, further discussions?
I think the engagements that I spoke about is the one that I said I cannot go into the details of that engagement.
Now, you cannot, okay. You cannot go into the detail as regards those engagements, and please say it again, because, well, what is your reason again? Which right are you asserting this time?
It's both because I've been questioned about him, and there's a statement that is made, the 204 statement, and also is because there's an investigation that is currently ongoing.
Okay. Then let's take it one at a time. The Section 204 statement is made by who?
By myself.
In which matter? Or regarding which investigation?
The Medicare matter.
Medicare matter.
Yes.
And I take it that a Section 204 statement is one that would effectively render you a state witness.
No, I'm not a state witness.
Okay, so what Section 204 statement are you talking about? Unless I've got my CPA all mixed up.
I do not know how. Sorry.
Yes, I think Advocate Missy might help.
Chairperson, if I may interject at this point. Chairperson, you'd have noted earlier on we made reference to the fact that some of the claims to privileges that he wants to lay are in relation to the questions that were asked to him during the interview for this. And may be found in the Section 204 affidavit, which is a privileged document, and which is why we were of the view that the attorney on record would be another individual who is also an officer of the court who can confirm that he really is a suspect with regards to these interactions with said individuals, and therefore would be in a position to claim privilege. And so, which is the reason why Mr. Matlala keeps making the submission that I cannot speak to this here because I'm being investigated. I've addressed it in the Section 204, and you would note that when you are being investigated as a suspect, as far as I understand, it's not specified to you that your charge is A, B, C, D, E, F, G. And therefore, it makes it even harder for him to pinpoint exactly why said information was required for me to give to the individuals during my Section 204. And therefore, I need to claim privilege over this particular point. Chairperson.
Oh, Ms. Zillo will respond. But may I say this so long? My understanding of how Section 204 works is that somebody who may be charged of an offense or who has even already been charged of an offense may then be engaged by the prosecution to be used as a state witness. And then in terms of Section 204, that person may then be discharged in the sense that they will no longer be charged with that offense. But if they answer all questions truthfully and satisfactorily, and they are even called a Section 204 witness. So just before or what you call an interjection, Ms. Sillo wanted to understand if by his repeated references to his Section 204 statement, he is suggesting that he was or was to be a Section 204 witness. Yes, Mr. Law.
Indeed, Chair, that is what I'm trying to understand, because if it is in respect of Medicare 24, what we know right now is Mr. Matlala is an accused person. If he has signed a 204 affidavit, which, as the Chair points out, he could be discharged from the charges that he's currently facing, and I need to test whether or not he's an accused or he has become a state witness in the Medicare matter, which, as I understand it, is the matter in which he deposed to a Section 204 affidavit.
Or if none of those, how then does a Section 204 statement feature?
Chairperson, my apologies. So the plea agreement fell through at that point, so it didn't become a Section 204. to my understanding. And so with that being said, that information then made him understand that with regards to point A, B, and C, D, I'm a suspect and I'm being investigated. And that's how we have come to the conclusion that he may be in a position to claim his right to privilege.
How do we, without sight of the 204, how do we as commissioners determine whether the reliance on Section 204 is properly raised? And that properly as in is it's validly raised and it should be upheld?
Chairperson, in that instance, we tried to aid the situation or the dilemma that we also had come to, as per your question. And the only solution that we could come to is that the attorney, being an officer of the court, would be in a position to confirm that indeed, to the extent of ABCD, having read this affidavit, we can confirm. And I believe from that point, then it would put the commission in a better position to say, well, Mr. Matlala and through his legal team are actually correct when it comes to ABCD. But as it stands right now, it would be impossible for him to engage you with regards to those points. And again, as we had apologized with regards to not being able to deliver the replying affidavit timeously for the commission to have sight of it, because that's the main reason why we needed the instructing attorney to both have a look at the docket and the Section 204 and give the commission an insight into it.
If I may, I think there is a third option that perhaps Advocate Nis is not alive to, which is providing this commission with that Section 204 affidavit, even if it's on a confidential basis, for the commissioners and the evidence leaders to consider the contents thereof, to appreciate the rights that Mr. Matlala seeks to assert at every turn as a result of that Section 204 affidavit having been deposed to.
If I may just add to that, because I was going to say something along those lines, that if his attorney, and underline this which you said, is an officer of the court, and therefore we must take his word for it, why does that not apply to the evidence leaders who are also officers of the court and officers of the commission and the commissioners as well, as a quasi-judicial body made up of lawyers? Why does that not apply to them? And that's aside from the question of, surely you couldn't be saying that the word of the attorney must be taken to be the word of Mr. Matlala. And if the attorney says, that's what that affidavit says, we must blind to the document. And without it coming from Mr. Matlala's mouth, we must accept that what the attorney says, we have to make a decision on that basis. On what authority? On something so important and with far-reaching consequences, on what authority would you say we must proceed in that way? Because it's not just a matter of preference. You obviously prefer that. So put preference aside. It doesn't work on preference. It works on what is the authority for denying the commission the access to that Section 204 affidavit, especially where Mr. Matlala has repeatedly invoked it and offered, he's referred to it. It doesn't come out of a vacuum. We are having this conversation because the witness in the box keeps saying, it's in that affidavit. Why are we not entitled to look at it? And the answer to the why must be, on this authority, you are not allowed to look at that Section 204 affidavit.
Chairperson, if I might be given a moment to just confirm with my learned friends. Chairperson, if I may. Commissioner, in terms of section 10510, when you're no longer a state witness,
Of the Criminal Procedure Act.
Yes, of the Criminal Procedure Act, you are then given a right of privilege over any information that you would have deposed to in the initial affidavit. And the moment you expose that affidavit, any and all issues that are addressed in that affidavit are now in the fray. And you waive your right to not be, you waive your rights that's given to you in terms of section 10510. Consequence to that, what we consider is that if there's even any other issue that he has addressed in that affidavit that he's given privilege over, even if you hadn't considered it, if we expose it to the commissioners and not through his attorney who has legal privilege, it then implies that you would have seen all the information that he's given protection over, which you wouldn't ordinarily be entitled to, which is protected not to disclose to anybody else, as we have now established that he's not a state witness, Chairperson.
Thank you, Commissioner. Perhaps we might benefit from taking a step back, and I do so by posing a question to Mr. Matlala. Mr. Matlala, you concluded what we call a Section 105 capital A plea and sentence agreement with IDEC, didn't you, in this Medicare matter?
Yes, that's correct.
And that agreement was presented to the court as it ought to be and was considered by the court, and the sentence was rejected by the court, and the court counter-offered with a higher sentence.
That's correct.
Which, in terms of the law, you have a right to consider, accept, or reject, and you elected to reject it on the 13th of July 2026 at your appearance in court.
Yes, that's correct.
And you accept that once you rejected it, the entire Section 105A plea and sentence agreement fell by the wayside. It became null and void.
Yes, that's true.
Now, the affidavit that we are discussing now, you deposed to in the process of negotiating that Section 105 capital A plea and sentence agreement, am I right?
Yes, that's correct.
Now, both of them have since become null and void. Do you accept that?
Yes, I accept that.
Okay, this perhaps now to address myself to Advocate Misi. The subsection 10 of 105 capital A simply says that the trial starts quote unquote de novo, and the contents of those documents are not applicable as against the accused person in that particular trial. That's what the subsection provides. Now, Advocate Misi seems to extend that to suggest that both documents cannot be considered, even if it's not to determine the guilt or otherwise of the witness before us, but because they've become null and void for purposes of that criminal trial, therefore some privilege extends to them. I'm still unclear, Commissioners, what privilege exactly Advocate Misi is extending. Thank you.
If I may, Chairperson, I have here before me the actual provision. And at subsection 10, from letter number B, sub B. No, my apologies, sub A. Unless the accused consents to the recordings of all or certain admissions made by him or her in the agreement or during any proceedings relating thereto, any admission or record shall stand as proof of the admission if it does not fall de novo. So our understanding and interpretation is that the fact that he does not consent to waiving his right with regards to the information that he had given willingly in lieu of the fact that he would stand as a state witness, it then implies that he's covered not to disclose any such information that he had given willingly in lieu of the fact that he would be a state witness. The problem then becomes in the instance where this document is regarded as a privileged document. And by my understanding, and it is our argument, the submissions, right, that if we then say outside of his attorney and legal representatives who have privilege over this information, we hand it over to the commission, it then implies that not only are you going to be able to look at those particular statements that you're asking questions about, any and all information that is disclosed in there that you possibly have not even considered asking questions about. It puts us in a position where you have sight of it and you very well might say, well, but we think and we consider this not to be something that's privileged. And so I do not understand how is it possible that the commission would be able to close its eyes to any other point that's made there and only look at those particular averments that he makes that relates to the questions that you are asking. Because and our understanding is that the moment he says you very well might look at that affidavit, he loses his privilege not to have that information that is given during those proceedings exposed.
Chair, if I may, and perhaps it's time to turn to Section 105A. The rights that are protected in that section, particularly paragraph sub 10, which Advocate Missy refers to, are intended to protect the accused against any prejudice as a result of the agreement concluded or the plea and sentence agreement in that particular trial. That's all. Advocate Missy suggests that the privilege extends to the world at large, whereas the privilege in terms of the section itself protects the accused person again in that particular trial, where he deposed to both the plea and sentence agreement and the Section 204 statement affidavit. So, Commissioners, I suggest there is no legal basis to refuse to provide both the sentence and plea agreement, which has since become null and void because Mr. Matala rejected the proposed sentence on the 13th of July. And it is literally pro non scripto. It cannot be used against him in that court. Similarly, the Section 204 affidavit that he deposed to. Both documents can never be used against him in the trial that he's currently facing. Section 105, capital A guarantees him that. So if they are going to argue for non-disclosure, I submit that they have to advance a different legal basis for the non-disclosure, not reliance on Section 105, capital A. This is not a court, a criminal court sitting in the Medicare contract criminal case. Thank you, Commissioners.
Ms. Missy, well, first to make the obvious point, Mr. Matlala is not in a criminal court before us. He's not an accused before us. That's the one point that Ms. Lawyer is making, and it's my point too. But two, it seems obvious to me that Mr. Matlala can't have his cake and eat it. He can't invoke the Section 204 affidavit when he's required to answer questions. He can't say, it's in the Section 204 affidavit, and so I don't want to deal with it. And then at the same time, say you can't look at the Section 204. Then if that were to hold, and I've said to you on what authority would that ever hold, if that were to hold, it would mean that, in fact, he just needs to assert it. He just needs to say that if I answer that question, or if I speak to that, whatever you're asking me, if I give you an answer, I'm self-incriminating. And if your proposition or submission is correct, it would mean that's the end of that inquiry. It would mean that. And I want to suggest to you that the correct position has to be that what he asserts when he invokes that privilege against self-incrimination, it requires that we must assess and evaluate whether that defense or that protection is being properly invoked. And the only way we can determine that is by looking at what it is that he's refusing to answer. I'm still to hear you say that we are wrong in that position, that in fact his say-so is sufficient. And if you are correct in that proposition, then we could never, ever, ever make any inroad with any witness, because all witnesses can come and sit here and say, well, you know what, there's a recording, and in that recording I say things that are being investigated. That's the end of the matter. Similarly, for Section 204, all he needs to say is there is a 204 affidavit. If I speak to it in any way, then I'm incriminating myself, and that would be the end of the inquiry. We would never have a witness that answers questions. You may, if you have an answer, you may respond to me and to Ms. Silo.
Chairperson, it's not an answer, but my question then would be, are we to say that the rest of the provision that refers to during or any proceeding relating thereto, that in these proceedings in the Commission, we are excluding the Commission to include any proceedings relating thereto?
What is the relating thereto? What is the thereto that is referred to?
The agreement, to be precise.
These are not proceedings about the agreement. We're not having a trial that relates to anything that affidavit may be covering. We are not having a hearing about that agreement if the thereto is the agreement. We are not doing that. We are engaging, and I want you to remember how we get to this point of discussing the Section 204, is because Mr. Matlala repeatedly makes reference to the section 204. He says, I'm not answering that. It is in the 204 and all of that is being investigated, is under investigation. That's how we get there. And for me, the fundamental question is a witness entitled to say that which you're asking me is in a document, but you can't see that document, and that's a complete answer? It cannot be.
Commissioner, we're not saying that it's just in any document. We're saying that it's in a document that is privileged. And in terms of which that agreement, the moment you don't become a state witness, it falls away and nobody has to have sight of it. Because it then goes to the fact that he willingly brought himself and has made admissions, all types of admissions, to which, as the commission, because you are investigating some of these occurrences, these events, and perhaps even the evidence that he makes reference to, it then implies that any witness that comes forward and says to the state, I am willing to be a state witness, let's negotiate. If that negotiation falls through, any commission at that point will not respect the fact that your admissions and the privileged document that you had entered into an agreement about is no longer privileged simply because you are called before a commission.
You see, we did not have, I hope you are listening to me. I hope you are listening to me. We did not have to get to this point, and I'm addressing you as well, Mr. Matlala, on this. We did not have to get to this point about whether or not this Section 204 statement or affidavit or the contents of it should be divulged. Mr. Matlala could and should actually have responded to the question directly. If Mr. Matlala said, your question relates to A, B, C, D point, which is about one of the crimes of which I have been charged, therefore I risk incriminating myself, that we would understand. There is no need for him to refer to the Section 204 statement as some umbrella cover for his protection. As I said earlier, there is authority from the Constitutional Court that says you must clearly identify the crime to which you are referring in asserting your privilege. And then that should take you to whether, in the face of that, the question put to you is a question that you should or you should not answer, based on whether the privilege under those circumstances can be asserted. You don't have to refer to Section 204 or the statement that you made under Section 204 and to then use that as some overarching protection. Once it's in the statement, therefore, I cannot answer questions relating to it. It should not. I see your junior next to you is shaking her head. Maybe she's going to give you some brilliant point on why I'm talking nonsense. So, we do not have to go there. We are not asking for the contents of the Section 204 statement. All that we want is, because Mr. Matlala is asserting the privilege, Mr. Matlala should say, this is the crime, and this is how your question impeaches on my privilege. That has nothing to do, and it should not have anything to do with reference to the Section 204 statement. It does not have to. And I repeat what I said right at the beginning, which is that without this umbrella cover all that Mr. Matlala uses, we should not have been in this position whatsoever. So much that I will perhaps, I'll let you respond. Depending on your response, after the advice from your junior, I will then ask Ms. Sillo to repeat her question. And I hope Mr. Matlala has heard me when I say, we do not have to just broadly and in general terms refer to a Section 204 statement and then say every and anything that relates to the questions you are asking me is contained in that Section 204. That's not the test. The test is there a crime? What is that crime? How does the question being put to you relate to that crime? And are you therefore entitled to assert the privilege? The test is not, this has somehow been touched on in my section 204 state. That's not the test. That's simply not the test. Yes.
Chairperson, if I might just get a moment to just confer, because I can hear as well that my junior does have a few points that she perhaps wants to relate to me that I
Yes.
missed. Thank you.
Should we take an adjournment and you'll then indicate when we should come back? No, please feel comfortable. Don't rush yourself because you want to make sure that you will convey what's being said to you. But of course, we had indicated that we would be taking the adjournment at 5. Let's adjourn rather than us just sitting and watching. You'll indicate when you are
Thank you,
ready.
Chair. Yes.